All right, everyone, we are going to go ahead and get started. First and foremost, good afternoon to our audience, and thank you for taking the time for joining us for today's Proposition 19 Virtual Town Hall. My name is Tittle Geen, and I am a Special Assistant Field Deputy here with the Office of the Los Angeles County Assessor, Jeffrang. Before we begin this afternoon, I did want to point out a few housekeeping notes. Today's Town Hall is being recorded. So this recording and all information will be made available to the public following the conclusion of today's events. The goal of today's town hall is to solicit frontline experiences from the public to aid us as we determine the path moving forward in implementing Proposition 19. Over the last few weeks, we've received hundreds of questions surrounding Proposition 19 and its implementation process. Assessor Jeffrang, Chairman Vasquez, Special Assistant Robert Isazaki, and Nicole White-Gamble, Director of Operations and Role Services, will be answering some of those questions, and any additional questions you have for the assessor and the chairman may be submitted via the Q&A function at the bottom of your screens at any time in the event. Please be mindful to not use the anonymous function when submitting questions, as our office will not be able to connect with you after today's town hall to get any of those additional questions answered. As previously mentioned, today we are joined by LA County Assessor Jeffrang and Board of Equalization Chairman Antonio Vasquez. I did want to take a second to introduce our panelists, and I will start with the chairman. Antonio Vasquez, chairman of the Board of Equalization, representing the 3rd District, was elected to the board in November of 2018. His district includes most of Los Angeles County, all of Ventura County, and a portion of San Bernardino County. He is the first Latino ever elected to the BOE since its inception. Vasquez brings to the board over 20 years of business and government experience involving strategic and long-term planning, business development, and municipal and legislative advocacy. He is known as a tireless advocate for responsible growth and development, fiscal responsibility, public safety, affordable housing, open and responsive government, and education to improve the quality of life for all Californians. Among his many accomplishments are over 10 years of service on the Santa Monica City Council, including terms as mayor pro tempore and mayor, serving as a Southern California Regional Director for California Futures Network, and as well as community planner for the United Way of Greater Los Angeles. Chairman Vasquez, thank you for joining us. Would you like to say a few words before we begin?
Sure, thank you. Thank you for that introduction. And well, let me just open up with first thanking my assessor, Jeffrang, for the invitation to co-host this Proposition 19 Town Hall meeting. And before I began, I wanted to also recognize and extend my condolences to many of the folks who have lost loved ones during this pandemic. And especially and sincerely thank all those that are still working on the front lines to help us prevent this pandemic from getting any worse than it has already. So let me just do that. And it's my pleasure and honor to have the opportunity to share a look at what the California State Board of Equalization, the BOE, has been working on to implement Prop 19 as it was passed by the voters in 2020. With that, but first, I guess before we dive into that, I wanted to give a little background information on the BOE for many of the participants that might have logged on and don't know exactly what the BOE does. The State Board of Equalization was established in 1879 under the California Constitution to ensure that county property tax assessment practices were equal and uniform throughout the state. As the nation's only elected commission, the board has 5 elected members who serve concurrent 4-year terms. Their popular election ensures that the board's tax programs administration remains directly accountable to the people. There's 4 districts, and you mentioned in your opening remarks that I represent the 3rd district. There's 3 other districts besides mine, the 3rd district, that constitutes the State Board of Equalization. The 5th member is our state controller, Betty Yee, and she serves on the Board of Equalization as an ex officio member. And then we have, and as this board, we basically ensure guidance to the 58 assessed counties throughout the state of California. And Prop 19 has been one big, huge one where we've actually had to already put together 12 LTAs, which are advisories to the 58 counties on how to implement and roll out Prop 19. The work of the board has been done, has been largely been centered around property taxes. I encourage the public who's participating in this session to constantly keep up and look into our website, because our BOE website, which is www.boe.ca.gov, is constantly changing as we hear and we provide more guidance to the 58 counties, specifically around Prop 19. So hopefully in this interaction we have today, if we don't answer all your questions, please keep checking in to our website, and also feel free to log in to our monthly meetings, which are also posted on our website. We actually have a meeting coming up on the 14th that is open to the public. And we have on our agenda at every meeting since Prop 19 passed a item specifically to address any new changes or recommendations or advisories on Prop 19. So I encourage you to all keep track of that and log on. And if you come up with any suggestions, recommendations, or issues as you're moving forward with any transactions you're making around Prop 19, to please reach out to our office and let us know.
Perfect.
I'm sorry.
No, I want to say thank you for that introduction to the BOE chairman, and thank you for joining us today. We're looking forward to having you answer some of our questions. And I did want to go ahead and introduce our assessor, Jeffrang, so that we can go ahead and get to that meat of what we're all here for. LA County Assessor Jeffrang was elected in 2014 as the 27th assessor for the County of Los Angeles and reelected in 2018. Upon taking office in 2014 as the Los Angeles County Assessor, Mr. Prang implemented sweeping reforms to ensure that the strictest ethical guidelines rooted in fairness, accuracy, and integrity would be adhered to in his office. Assessor Prang administers the largest office of its kind in the nation, with over 1,300 employees, that provides the foundation for a property tax system that generates over $17 billion annually. Assessor, thank you for taking the time to join us and for hosting today's town hall. I'm going to let you go ahead and say a few introductory words.
Thank you, Ted. Thank you, Chairman Vasquez, for joining us. The property tax administrative system includes a number of departments, both at the local level and the state level, and assessors work hand in hand with the Board of Equalization. And the chairman and I have been working very closely to respond to Prop 19 to ensure that it could be administered properly. And appreciate his efforts and all of you for joining us today. We have almost 500 people on the call, and about almost 1,000 have had RSVP'd, so folks will probably be signing on. We're going to be answering all your questions, both in the chat. If you registered and we have your email address, we will make all the answers to questions available to everyone, and this will also be reposted on our website. The reason why we're having this meeting today is that Prop 19, which was adopted about a year ago, has been a very significant challenge for the Board of Equalization and for county assessors to implement. We're looking to put our thumb on the pulse, if you will, of the community to find out what's working and what's not working. We anticipate that we're going to need additional legislation next year to do additional cleanup to make sure that Prop 19 works in the way the voters intended. Just to give you a little bit of a background about Prop 19, it was proposed by the California Association of Realtors and placed on the ballot by the legislature last fall. Unfortunately, it was written rather hastily. As a result, there were a lot of deficiencies in the measure that made it difficult to implement. So assessors have been trying, when Prop 19 passed last November, my office, as well as the Board of Equalization, a number of other offices got together to try to determine what we need to do to implement Prop 19. But what I can tell you is that as adopted, Prop 19 was practically unenforceable. There were numerous ambiguities, contradictions, and other deficiencies. We did a deep dive analysis of the measure right after November, going into the new year, and we put together proposed legislation that we thought would fix a lot of these administrative deficiencies. One of the first challenges we had right off the bat is Prop 19 only gave assessors 3 to 4 months to implement the measure. And this was the first obstacle. The requirements for us to implement Prop 19 required fundamental changes to our organizations, both in terms of operations and technology. And quite frankly, if they had asked us in advance of writing this legislation, we would have told them that conservatively, we probably needed 18 months to fully implement this measure. But the law went into effect, one component went into effect in March, and the other component went into effect in April, and we were simply unprepared. As is often the case with ballot measures, this one needed legislative clarification to help assessors and the Board of Equalization untangle the many ambiguities in the adopted language. It took several months to get legislation written and introduced, and that legislation was only introduced after the measure went into effect. Senate Bill 539 addressed most of the big picture deficiencies in the law. However, that was only signed by the governor as of September 30th. So one of the things we're hearing a great deal of, and I think we're going to have a lot of conversation about today, is that folks have filed for a Prop 18 many months ago, or 19 and filed many months ago, and they haven't heard anything yet. And the reason being is that we didn't know how to administer it. We didn't have the state guidance. As assessors, we're not policymakers. We can't create law. We have to do what the law says, and the law was insufficient. So we've been operating for months with very little clarification. Now that we have the law into effect, we are now rolling out the implementation elements of it. But hundreds, if not thousands of applications have come in. They're piling up. There are delays. We're doing the best that we can do to coordinate all the logistical and technological changes necessary to process those. But unfortunately, it's going to take a little bit more time till we get to that point. One of the things we are learning is, even though we did a deep dive, made a best effort to try to identify what those legislative needs were, we don't think we got all of those needs addressed in Senate Bill 539, and we're pretty confident we're going to need to go back to the legislature next year. And we want to make sure we do a thorough inventory of what all those needs are, so that we can have those in place as quickly as possible. I did want to emphasize that we do have on our website, as well as I think on the Board of Equalization website, a lot of tools, information, and resources regarding Proposition 19. We try to update it as we learn more about it. But that's the genesis about why we're here today. We want to hear from you, answer your questions, and tell you what where we're going in the weeks and months ahead, and what to expect. And we're hoping that we're going to learn some things from you that could help us improve our operations, and will help us when we go to the legislature with these additional needs for corrections next year. So that's my summary. I'll turn it back over to you, Ted.
Very well said. Thank you for that introduction to Prop 19, Assessor. And as previously mentioned, today we are joined by Nicole White-Gamble, who is the Director of Operations and Rural Services. I know that the Assessor just gave us a pretty detailed background of Prop 19 and where we're at. But Nicole, would you be able to give us a very brief rundown of where we are in the implementation process here in the Office of the Assessor?
Thanks, Ted. I just want to really jump in with what Assessor Prang has already stated, but from the very forefront, he's been a leader in this, and there have been a couple priorities. One is, of course, trying to get clarification, uniting people within the state. And also it's been for us to figure out and educate as much as possible throughout this whole process. Education has been key, and Assessor Prang is really taking the lead in terms of jumping out there and providing information even when things were gray. So right now where we are is we're at a place now where, as he said, we have received literally thousands of exclusion claim forms, and we typically get quite a bit, but it's doubled. And so we're trying to prioritize getting information out in terms of notification, one, to verify that we've received information from taxpayers in claim forms, but also because of the aggressive nature associated with many of the exclusions right now, we're trying to make sure that people know what they need to do so they don't miss very important guidelines. So system updates are being taken place at this point in time. We are also training and making sure that we can process things throughout. We're creating the appropriate workflows, et cetera. And it is a momentous project for us to work on, but we're trying to be very responsive throughout.
Great. Thank you so much for those updates, Chairman Vasquez, Assessor Prang, Nicole. I know our audience really appreciates it, but now I know we have a lot of ground to cover. So if no one minds, I would like to transition into our first segment of today's town hall. Today's town hall will be comprised of 4 individual segments. The first being intergenerational transfers, followed by base year value transfers, followed by process and efforts to repeal. And finally, we are going to wrap up with additional questions received via the Q&A function at the bottom of your screens. Let's begin our segment by covering intergenerational transfers today. Assessor, this question, I'm going to field it to you. One of the most common questions that we've received in the planning process leading up to this town hall is, do I have to claim the homeowner's exemption to qualify for the parent to child and grandparent to grandchild transfer exclusion? Would you be able to clear that up for the audience?
Yes, it is mandatory that you file the homeowner's exemption. Homeowner's exemption is a very modest tax savings program available to anybody who owns and occupies their home, but it's taken on a whole new level of importance under Prop 19, because Prop 19 for the parent to child exclusion requires that the only property that your children may inherit from you, along with your tax base, is your primary residence. And the only way we know that that's your primary residence is if you, as the parent, have a homeowner's exemption, and upon your passing or your transfer to your children, that they file the homeowner's exemption. Though that is the enforcement mechanism that we need. Without that, the property will be reassessed to market value. It is a critical component.
Thank you for clearing that up, Assessor. And for those who don't know where they can apply for this exemption, where can they go?
On our website, there is a tab that talks about tax savings. One of those is the homeowner's exemption. It's a very simple form. We simply need your basic information. And unfortunately, it still requires a wet signature. It has to be mailed in. That will change probably in the next 24 months when we do it all digitally. But you just need to fill out that form and mail it in. It's not a complicated form at all. And you only need to do it once. They'll stay with you as long as you own the property.
Perfect. And just so our audience hears again, if you need to find that form, it is available on our website. So you can find it there, like the assessor said, with signature, and mail that into us. And Assessor Prang, I do want to continue on this theme with another question for you. Under Proposition 19, can multiple children inherit a single property and retain their parents' base year value?
They can. This is actually an interesting point, because it gives you a little bit of the window, our window into the things I was talking about, the ambiguities in Prop 19. So the way Prop 19 was written, it said that your children could inherit your property and the tax base. But as written, it would have required, if you had more children, it would have required all of them to live in the home, kind of an adult family reunification mandate. Obviously, that's not what they intended. That is what they wrote. The legislation, Senate Bill 539, corrected that. So now if let's say there's 4 children inheriting the parent's property, the law only requires that one of the children live in the property. It also allows all the children to decide at different times if a different one would live in the property. As long as there is a child who qualifies living in the property, the tax base can be transferred. It is important to note, though, that is in perpetuity. The moment a child is not living there, the property gets reassessed.
Great. Thank you for clearing that up for us. And Chairman Vasquez, I would like to direct our next question to you. Under Proposition 19, if a parent transfers one property to one child and another property to another child, can both children retain the parent's base year value?
No, no, only the one principal resident of the parent to qualify for eligible transferee who claims the ownership exemption can qualify for that.
Got it. Simple and easy. So now here we have a real life scenario submitted by one of our audience members. This scenario says, my mother held her property in an LLC. She recently passed away. Is the date of death transfer eligible for the Proposition 19 parent to child transfer exclusion? Rob, I am one of our special assistants from the office. I know we have you on this call. Would you be able to go ahead and clear that up for us?
Yeah, sure. Thanks, Ted. So in this particular case, the Proposition 19 parent-child transfer exclusion is not going to apply. The exclusion applies to transfers of real property interests between parents and children. However, it does not apply to transfers of legal entity interests between parents and children, even if those legal entity interests are also associated with real property.
Perfect. Thank you for helping us understand that, Rob. And I do want to wrap up this first segment covering intergenerational transfers with a question concerning property held in a trust. Assessor Prang, I'm going to actually direct this question to you. How does the Proposition 19 parent to child transfer provision affect property held in a trust?
So just to be clear, a trust is simply a set of instructions as to what is to happen with the property when the trustor dies or agrees for the point of transfer. So you're still obligated to take certain steps upon the death of a property owner, even if that property is in a trust. And if we're talking about a parent to child transfer, there are two minimum things that need to happen. The trust is not autopilot. It doesn't do these things for you. You still are required to do them, even if the property is a trust. The first one is you are required within 150 days to file what's called a change in ownership, death of real property owner form. That tells us that the property has changed hands. Failure to file that in a timely manner could complicate estate planning considerations. The other one, if you're going to inherit the property under Proposition 19, you've got to fill out a Proposition 19 application. None of these things are automatic. We don't know what your individual family circumstances are and how that ownership works. If we don't have that information, we will perceive that as a transfer of real estate and the property will be reassessed. One of the things I want to emphasize on this point, though, is Proposition 19 has a very rigid implementation deadline. Everything needs to be done within 12 months. You need to file the death of real property owner form, the Proposition 19 form, and the children moving into the home have to file the homeowners exemption. And it has to be done in 12 months. The previous law allowed, sometimes people didn't know what to do, they neglected it, they forgot about it. Sometimes several years could go by and we were oftentimes able to apply the tax benefits prospectively. Under Prop 19, it's a hard and fast 12-month rule. There is no discretion. If you don't do it in that period of time, the property gets reassessed.
And it looks like we have Chairman Vasquez who wants to go ahead and chime in. Did you have something to add, Chairman?
Yes, just one thing. There's a real good resource for those listeners, especially on this question about the trust. If you look at our website, we actually have under property tax rule 462.160 gives you a more detailed explanation in case, whoever asked this question isn't clear or has other questions about how to handle the trust situation in their property.
Perfect. Thank you. Thank you for those additional resources, Chairman. And before we move on to our next segment, I did want to put our Special Assistant Robbie Suzaki in the hot seat and have him clarify the homeowners exemption filing deadline for us, just because I know that a lot of these deadlines introduced by Prop 19 have been very ambiguous, and I want to make sure that all of our attendees know when these deadlines are occurring and when they need to file by.
Sure. So as the assessor pointed out, one of the things that came into effect under Prop 19 is that very important one-year filing deadline for the homeowner's exemption claim after the transfer has occurred. Also, though, we have recently received some clarification on the filing of the claim. I believe the claim is still allowed to be filed within 3 years of the transfer date or before the transfer of the property to a third party. So it is a little bit more expansive than the one-year rule. Again, that's something that was recently clarified by the new legislation, but again, as the assessor pointed out, it's 1 year hard and fast rule for the homeowner's exemption claim.
Okay, thank you for that additional clarifying information, Rob. I know that our audience really appreciates it, but this does wrap up segment 1 concerning intergenerational transfers. Like I mentioned before, if you do have any additional questions concerning this segment or any of the additional segments we are going to cover, please use the Q&A function at the bottom of your screen. Submit those questions. We are going to be answering additional questions at the end, so please use that function so that we can get your questions answered. But now that we've had the opportunity to cover our first segment, I did want to transition to our second segment of the afternoon that will cover base year value transfers. Assessor, I want to start with you again. One of the most common questions we received in preparation for this town hall is, under Prop 19, how many times and where can I transfer my base year value? Would you be able to provide a response for the audience?
And so this actually really speaks to why Proposition 19 was introduced. It for qualifying homeowners, which are those who are 55 years or older, severely disabled, or the victims of a natural disaster such as a flood, a fire, or an earthquake, you can now transfer your property. When you sell your home and buy another one, you can transfer it up to 3 times. So it essentially makes your property tax basis portable. You can transfer it to a home of any value, which is an improvement over the previous law, which only allowed you to transfer it to a home of equal or lesser value. And now you can transfer that tax base to any county in the state. The previous law only allowed you to transfer it to one of about a dozen counties statewide. So that is a large expansion of the benefits to those qualified homeowners. So again, it's you can transfer it 3 times anywhere in the state into a home of any value. As a caveat, though, I want to note that if you transfer your property to a home of greater value than your current home, there will be a property tax adjustment. It won't be the full market rate; it'll be a blended rate of the value of the home that you're transferring, plus a market value for that additional home value that exceeds your current home value. It's kind of a complex formula. We'll get into that later on.
Right. Yes, and like the assessor mentioned, we are going to be diving into that formula to determine your new assessed rate a little bit later on. So thank you for introducing that for all of us, assessor. But as we heard during our first segment concerning intergenerational transfers, timelines with Prop 19 are very important, and there's been a lot of confusion surrounding them. Assessor Prang, again, this question is for you. How much time do property owners have to purchase a replacement property after the sale of their original property in order to qualify for a Prop 19 base year value transfer?
2 years.
How many was that?
2.
2 years. Great. So
I am correct on that, am I not, Robert Mizusaki?
Rob, did you want to go ahead and clarify that is correct?
Yes, that's correct, assessor.
Great. And now that we've had the opportunity to cover some of those timeline issues, I did want to go ahead and dive into that topic that the assessor mentioned a little earlier, which is how to determine new values for these properties, right? So Rob, I did want to send a question your way. if a property owner purchases a replacement property for less than they sell their original property, will they be able to transfer their base year value?
Yes, they will be able to do so. It's very similar to how the old law worked, Prop 1690. If a qualified claimant, in most cases, it's going to be a person over the age of 55 or older, or a property owner with a disability. If they purchase a replacement property for less than they sold their original property for, they'll be able to transfer their tax base over without any type of adjustment.
Great. And Rob, where can the audience find any resources for this? Can we direct them to our website?
Absolutely. On the assessor's website, we have a dedicated Prop 19 webpage. Specifically on that page, we have a Prop 19 base year value transfer calculator. So that should be able to assist with some of your preparations if this is a program you're looking into.
And like Rob was saying, the calculator that is available on our website is very helpful if you're trying to determine the new assessable value on your property. So if you're curious and you're purchasing a new home and you want to figure that out, please visit our website. That resource is available to you. But Rob, I do want to stick with you as we dive into this subject. And I have another question for you. If a property owner purchases a replacement property for more than they sell their original property, will they be able to transfer their base year value? So it's like if the situation was flipped, right?
Right. And this is something that the assessor touched on and briefly explained, but we can get a little bit more into the weeds with the calculation. So the short answer is yes. If you're a qualified claimant, again, based on age or disability, and you purchase a replacement property that is for more than you sold your original property for, you can still transfer over your tax base. However, in this particular situation, you would be able to transfer that tax base over with an upward adjustment. And the way that adjustment works is we will add the difference between the sales price of the difference between the purchase price of your replacement property and the sales price of your original property, the difference between those two values, and we will add it on top of the transferred tax base. So that is what accounts for the increase. But yes, you can still transfer your tax base over.
Perfect. Thanks for helping us clear that up. And this is a question that we've received from the audience. If Assessor Jeffrang or Chairman Vasquez, if you would like to go ahead and take this, either of you, regarding the base value transfer, are you able to buy first and sell the original home later?
That's a hard one, Tony. How would you take that?
Yes, it's my understanding they can.
That I'm sorry, Chairman, that they can or can't?
They can.
They can.
And matter of fact, if they check our website, we have cited several examples that they can follow.
Perfect.
Kind of walk you through it.
And these examples you said are available on the BOE website?
Yes.
Great. So as you're hearing, audience, there are plenty of available resources to help you understand these new base year transfers. So please visit the BOE website as well as our own assessor website. But I did have another question from the audience that I would like to introduce since we are on this topic of base year values. Would anyone be able to define property tax base used in transfers in this circumstance?
Pitch that one to Nicole.
Hi, so I think there's a couple things we need to consider when we're talking about these. And essentially, we have the property tax base. We can think about our Prop 13 value, or when someone purchases a property and gets established, they have a base value that is established that typically at that point in time will not change except for like a CPI trend year after year. And typically this is what someone's trying to retain and transfer on to someone else or transfer to another property. We also talk about the taxable base value. And as we were talking about this, one of the elements of Prop 19 that is now start to introduce is that we know if we're talking about a base year transfer, that now because the property doesn't have to be equal or lesser, it can actually be greater, we know that it's possible that taxable value can be adjusted. And so in those instances where someone purchases a property and let's say it's more than the property that they sold, we'll have to adjust and get a new taxable value for them. And so that's why those distinctions become really important.
Perfect. Thank you for that response, Nicole. And I do have another question that I would like to go ahead and direct towards Rob. Rob, the question that we have is, if you have 2 years from the sale of your home, what tax basis will be used to assess the new home? And the follow-up question is, if you buy a new home first and then wait a few months later, how will the new home be reassessed?
So we will transfer over your tax base based on the latter of the two events that occur, because both have to occur for the tax base to be transferred. So I think, as Nicole was pointing out, the tax base that we transfer over is essentially what you were paying your taxes on prior to the sale of your original property. So whenever the completion of those two events occur, the sale of the original property and the purchase of the replacement, we will, and a claim is filed that requests that base year value transfer, we'll be able to do it at that time.
Perfect. Thank you for helping us clarify that, Rob. But Assessor Prang, I did want to pivot back to you with a question. Can a married couple transfer the base year value for their original property to a replacement property if only one of them is 55 or older?
Yes, as long as one of the qualifying property owners, as long as one meets the qualifications, it can be transferred.
So as long as one of them meets the qualifications, they can transfer. So like the assessor said, as long as one of these individuals is 55, that transfer is able to occur. But before we move on, there was a question that I saw in the chat that I thought was important to clarify in terms of definition for our audience. Rob, I'm hoping maybe that you can go ahead and answer this one for us, but would you be able to clarify the term severely disabled in order to qualify for Prop 19?
Yeah, so there is a definition that the BOE has provided. Unfortunately, I don't have it on hand just at the moment, but it is included in some of the letters to assessors that have been issued. So maybe Chairman Vasquez can speak a little bit more to those resources.
Chairman Vasquez, could you be able to provide a definition?
Yes, kind of going back to the question that you just asked the assessor. Under this new rule 462.540, the base year value transfer clarifies under Prop 19. And the assessor mentioned one of them has to be 55 and older. Actually, under Prop 19, if the person is severely disabled or is a victim of a wildfire or natural disaster, they also can qualify, even if they're not over 55.
Great. Perfect. Thank you for providing a definition to that. And where can we find these letters to assessors? Chairman Vasquez?
These are all on our website.
Again, all on our website.
If they go onto our website and there's a link you can click onto, it might be, the initial might be LTAs, which are letters to the assessors, and they're all published there. And you can get all the fine detail, especially as people are trying to clarify their situation.
Perfect. Thank you so much for helping us clarify that and for pointing us in the right direction to be able to access those resources, Chairman. But I know that we do have a lot of questions and concerns regarding the general process and efforts to repeal Prop 19. So I did want to kind of dive into that segment right now. I know there's a lot of activity happening throughout the state, and luckily we have Chairman Vasquez and members of the assessor staff with us today to provide us with some insight into that current landscape. Chairman Vasquez, I did want to go ahead and start with you and rely on your expertise for our first question. Has there been a system developed to monitor the number of times a property owner has transferred their base year value under Proposition 19?
Yes, the answer is yes. The BOE has developed a detailed tracking system that is being used by the board and assessors to make sure that everyone in the state has the same opportunity, that no one takes undue advantages under the law. And I guess we'll get into more of a discussion of some of the efforts that are going on, unless you want me to dive into it now, to make some possible changes and possibly even reverse Prop 19 down the road.
So we are going to cover that potential reversal in the efforts to undo Prop 19. So we will go ahead and bring you back in once we start those conversations, if you don't mind.
Sure.
But like I said, it seems like there's been a lot of questions concerning paperwork and the general application process of Prop 19. So I wanted to bring back Nicole from the assessor's office to go ahead and answer this question for us. Nicole, what paperwork does a property owner need to file to apply for a Proposition 19 exclusion or base year value transfer?
So the most important thing for everyone is, I think Assessor Jeffrang alluded to the fact with base year transfers, or I should say intergenerational or interfamily transfers, between parent and child or grandparent to grandchild, the homeowners exemption now becomes very important because this was not a requirement before. So I want to really emphasize the importance of that. And he's also stated that 1 year becomes really important. So if I'm talking about family transfers, the homeowners exemption is something that's new and important and has a very hard deadline of 1 year that must be claimed. But the other important thing is that a lot of times people indicate on their preliminary change of ownership report information that may indicate that they're going to have a transfer that may qualify. So they need to know that a claim has to be filed for each one of these. And there are actually specific claim forms for all the different instances. And these are located on our website. So if they go to forms, they can find one for a base year transfer for seniors, disabled, or they can find the family ones for parent to child, etc. But they are specific claims and they must be actually filed. So I'm gonna make that point.
Great, thank you for helping us understand that, Nicole. Rob, I wanted to field this next question to you. This is a real life scenario that we had submitted by one of our audience members. This audience member says, if I already stated on my deed and preliminary change in ownership report, AKA a PCOR, that the transfer was a parent-child transfer, why did the assessor's office send me a Proposition 19 parent-child transfer exclusion claim form?
Sure, and this is a kind of a topic that Nicole just touched on, but just to kind of go through it step by step, to obtain a Prop 19 benefit of any kind, you do have to file a particular Prop 19 claim form, whether it be for base year value transfers, whether it be for intergenerational parent-child transfers. So that's the important thing I think Nicole touched on already. Now, why would you receive a copy of those claims in the mail from us? The recording of a transfer deed or preliminary change in ownership report or PCOR, those do not constitute the filing of a claim for a Proposition 19 benefit. Even if those particular documents indicate that the transfer that's being effected is in fact a parent-child transfer. So as Nicole stated, when we receive those documents from the Registrar Recorder's office at the Assessor's office, it notifies us that that is the intent of the transfer. And so as a courtesy, we send out these claim forms to you so that you can file timely and appropriately. So it's not duplicative in any way. It's just a friendly reminder from the office that there is this additional claim that has to be filed, and now you have it once we've mailed it out.
Got it. Thank you for that, Rob. And Nicole, I know I let you go, but I want to bring you right back in for our next question. We understand that there are many concerns regarding processing time. How long is it taking to process Prop 19 parent-child transfer exclusion and base year value transfer claims?
So this is one of those answers.
Nicole, can you hold for just a second? Just to add to that while you're answering, and I saw in the Q&A session as well, so people want to have an idea of where we are in processing not only Prop 19, but also the Proposition 58s that we're piling up during this period of time.
Right. Thank you, Jeff, for that. And I'm going to have to start off with an apology and saying that this is something that we are working diligently to expedite the processing of these. But I have to give the context. We literally get thousands, tens of thousands of these exclusions every year. And prior to the change in Prop 19, we were seeing that type of increase where they were building year by year. With these aggressive dates, what we found is at the beginning of the year in February, because the date or the implementation effective date for the new rules was coming into play, we saw exponential increases in those types of applications. And so we have dedicated all the resources we can to try to get those processed as soon as possible. But In the meantime, when it comes to Prop 19, we really have focused on these new ones of getting notification out to people so they understand, one, we've received them, and also we've been asking for information. So Assessor Prang, when we look at that, the timeframes are varying. We are putting more resources as we speak to get this done. But again, there's still system changes and things are happening in the interim. I want to stress, since we have this forum, that when people are receiving requests for documentation from us, one way that they can really help us to expedite the review of their claim forms is to respond. Many times there's elements that are missing. There's verification information that we need, and we'll reach out to request this information. And so when people can respond back to us quickly, it's very helpful. And I also want to put this out that our Prop 19 inquiry at assessor.lacounty.gov is an email address, and we can put that in the chat. Prop 19 inquiry at assessor.lacounty.gov is one way that people can expedite and get their information into us, and also ask their Prop 19 questions. So right now we're actually reviewing all of the Prop 19s that have been received to date, and people can anticipate that they will be getting notification in the next couple of weeks to verify receipt, request information, etc. But there is a backlog in those reviews.
And Nicole, just so that our audience can go ahead and catch that if they didn't have the chance to, can you give us that email one more time?
Yes, thank you. I'll talk a little slower. It is Prop 19 inquiry at assessor.lacounty.gov. So I'm going to still ask that people bear with us in terms of us going ahead and processing those. We have prioritized getting information out to those who may have process transfers early in February, because we know by next February 2022, their window is closing for those inter-family transfers. So there's been a concerted effort to get information out to them. As Rob said, we've been actually proactively, as a courtesy, mailing out applications and also mailing out the homeowners exemption claim forms as well. So we hope they'll take action on those.
Perfect. Thank you again for those resources and for that information, Nicole. But I do want to go ahead and open up this part of the conversation to both Chairman Vasquez and to Assessor Prang, because I know that there's a lot of interest and concern surrounding the efforts to amend and to repeal Prop 19 potentially. So both Assessor Prang, Chairman Vasquez, what efforts, if any, are underway to amend or to repeal Prop 19?
Well, what I can tell you is that the Howard Jarvis Taxpayers Association, and I think I saw on the participants list that there's representatives of the Howard Jarvis listening in, they have submitted language to the Attorney General for something they call title and summary, which once that's approved, they will have the authority to begin collecting signatures to put another measure on the ballot. It's important to note that Proposition 19 was a constitutional amendment. So we cannot change the provisions of it either by legislation or by administrative direction. It requires another ballot measure. Howard Jarvis Taxpayers Association believes that the parent to child, the reduction in benefits for family inheritance, the parent to child, grandparent to grandchild were unfortunate, and I think they're unpopular, and they're going to try to have that component of Proposition 19 repealed. Obviously, collecting signatures statewide can be a big task. We'll keep you informed about what we know about that measure as it develops, but that is actively that undertaking is actively underway as we speak.
The other two measures that are out there that I'm aware of, one of them is ACA 9, which was introduced by the Assembly member Kevin Keeley, which is basically a constitutional amendment to reverse it. Now, this has to get 2/3 vote from the legislators to move forward. So that's another avenue that's in the process. In the event that the Jarvis group is not able to collect the signatures, hopefully we can get, especially those that are listening and are very interested in this issue, weigh in with their representatives, whether it's somebody on the Assembly or the Senate, to advocate for this amendment, which is ACA 9, because it needs 2/3 of that legislative body to move it out and get it onto the ballot. So that is another way. There's also SB 668, which was a Senate bill by Bates, but all that does is just delay it, the implementation, which because this thing was voted in by the voters, the legislator can't reverse it without bringing it back to the voters. It has to go back to the voters. That's why you see the movement going on outside with the Harvard Jarvis taxpayers group, and internally with the legislators with the ACA 9. But the ACA 9, like I said, even if it passes the legislative body, it still has to go before the voters to reverse it because it is a constitutional amendment.
Got it. So it does sound like there are plenty of efforts underway and that there is a lot of interest to like you both mentioned, to either amend or to repeal Prop 19. Do either of you have any last comments you want to make about any of those efforts before we move on to some additional questions?
I guess I would just, as I said before, I'm not a policymaker, but I've had literally thousands of conversations and Zoom meetings with people about Prop 19. And I do believe that when Prop 19 was put on the ballot, the campaign emphasized those components that benefited seniors and the ability to make their property tax more portable. The reduction in family benefits was an offset to deal with the potential revenue reductions by expanding senior benefits. And that component was not discussed during the campaign. So that's why we're having a lot of consternation right now. A lot of folks saying, I voted for the senior element. I didn't know I was voting to reduce the benefits that were the previously existed for my family. And that's a lot of the challenges that we're experiencing right now. Plus the narrowing, the severe narrowing of the time periods for applying these exclusions makes it much more difficult for people to comply. And property tax administration is already a very complex process. There's multiple departments that each have a role in it, including at both at the local level and the state level. So I hear and I understand that there's frustration, but I also did want to emphasize, I'm looking at the Q&A, a lot of people are very frustrated about the processing time. And I apologize for that. I know that other assessors, Board of Equalization, we really hate putting members of the public in this awkward position of not being able to get a response, but we are simply drowning in applications. And up until a little over a month ago, we simply had no direction. We weren't able to respond. And I don't want to sound like I'm complaining, but I kind of am, but the legislature only gave us 3 to 4 months, even though we've told them very clearly we could not do it in less than 18 months. So Nicole White Gamble and her staff are scrambling, and they're doing a really good job because we know that we are where the rubber hits the road. People will hold us accountable for these delays. We don't want anybody to be delayed. We're working as fast as we can, but we really were not prepared, and we needed more time. It's very, very complicated. It just cannot be done quickly.
Yeah, we hear you, Assessor Prang, and I did want to transition kind of to a hypothetical that still deals with repealing or amending Proposition 19 that I was hoping either you or Rob may be able to take on. But the question submitted by one of our attendees says, if Prop 19 is repealed or modified, will properties that have been approved be retroactive? Will properties that have been approved be retroactively changed?
So that's actually a really good question. I don't know that I can answer that one. Tony or Nicole, or maybe, but if they were to repeal Prop 19, would they?
Well, I think one of the things we need to look at, especially as we're crafting this new language on, let's say we put something, or whether it's the legislator or the Jarvis group, when they put something together on the ballot, I think we need to be actively participating to make sure that they include that, because you're right. In the event that, let's say they get it on the ballot, we have to make sure that it takes care of these folks that are kind of caught in the middle, that may have transferred their property or attempted to transfer their property under the old rule.
Yeah, just to elaborate, Chair Vasquez, like you're saying, it's going to really be dependent on the language. And so if it doesn't have specific language that talks about it being retroactive, it's possible it could be prospective for a period of time, but we'll have to wait to see exactly what that specific language is. And then based on that, that's how we'd have to implement or administer these reversals.
Got it. Well, thank you for those responses. This kind of wraps up our third segment of questions that we received beforehand in preparation for the event. And as you all have probably noticed, the Q&A function has been very active and very busy during this town hall. So I did want to transition and move into answering a few of these clarifying questions that we were unable to get to in our initial responses. So if you don't mind, we're going to do that for a couple minutes before we go ahead and wrap up this town hall. But one of these questions that we received, and Rob, maybe you can take this. It says, on the homeowner's exemption, if you inherit property, is the date of accusation the parent's date of death, or is the date a trust administrate or the date a trust administration is settled? Sorry for butchering that one.
No, that's a great question. So in situations where there's a death of a real property owner and property transfers down to their children, we go with the date of death. That's regardless of whether it's a trust situation or a situation where the estate is going to be probated. We go with the date of death, not any type of subsequent action date.
Got it. Thank you for that. Thank you for that response, Rob. And it looks like we have another question that kind of deals with the homeowner's exemption. Let's see, it looks like maybe there was a typo in this, but I'm going to kind of see if I can answer it the best that I can. On the homeowner's exemption, you cannot legally occupy the property until more than a year after death. So I'm assuming that's asking to go ahead and receive that exemption for transfer. Can you move into that property a year after, or does it have to be that 1 year timeline?
That might be best sent to Nicole or Robert.
Rob, do you want to clarify? Would you be able to clarify that for us for that homeowner's exemption? Whether they can move into the property a year after death, or does it have to be a year before death?
Sure. So as of right now, the way that Proposition 19 is written, that 1 year deadline, like Nicole and the assessor and the chairman were stating earlier, it's hard and fast. So it doesn't really provide for maybe some outlier situations where an individual may not be able to occupy the property as their principal residence. Again, the requirement under Prop 19 also is that they file a claim within that 12-month period. So whether or not it's denied may be a different matter, but they may want to go ahead and file that anyways. But yeah, as of right now, the law doesn't provide for many exceptions.
Got it. And we're going to go ahead and continue with this theme here for a second. This question from an audience member says, what if the previous owners did not have a homeowner's exemption filed? Will the new grantees or owners qualify under the Proposition 19 law?
Do you want me to field that one again, Ted?
Yeah, if you don't mind, Rob.
Sure. So as far as parent-child or intergenerational transfers are concerned, that particular exclusion applies only to the principal residence of the transferor or first owner. So I don't believe that the language of Prop 19 requires that individual have had a homeowner's exemption claim on the property, but that will make it a whole lot easier for us to make that determination when we're reviewing their claim. However, it does provide that the child or grandchild that inherits the property or receives the property, they do file that homeowner's exemption claim within 1 year. So that the filing for the recipient is a requirement.
Got it. And before we wrap up our town hall for the day, there are a few final questions that I want to go ahead and get to so that we can provide as much clarification for our audience as possible. Assessor, feel free to answer this this one if you like, or we can go ahead and have Rob or Nicole or even the chairman. This question is a real life scenario. It says, my father put his residence into a trust and provided for my brother to own the property, and upon his death, the property would go to me. How would Prop 19 affect this situation, if at all?
So there's a little bit of a nuance there, because I think the trust is saying that one of the siblings is inheriting the property. And I think I may need to rely on Robert to help on this one, because this sounds like a stepped transaction where we go from the parent to a child, then to another child, but the trust provides for only the one. Would that, because there is still a parent-child relationship, would that brother be able to and then transfer that parental transfer to his brother under that circumstance?
Sure. So I think, as the assessor kind of suggested, all trust documents are a little bit different. And as he indicated earlier, they are precision instruments, and we have to interpret them according to their specific terms. In this situation, it seems as though the father has placed the property in trust for one of his sons to own the property during the father's life.
You're correct.
After the father passes away, the property is to be transferred to a second son, not the one who owned it while the father was alive. In that particular situation, based on the facts of this particular question as it's worded, I would say that would not qualify the transfer from the one brother to the other as a parent-child transfer. It's a transfer between siblings for which there isn't currently an exclusion.
Got it. Well, thank you for for clarifying that for us, Rob. And we're getting ready to wrap up. Here is our second to final question. Let's see. This audience member said, what happens when an heir inherits, gets the existing parent's tax exclusion, and at some point needs to move out for a while? This could be due to a job, for example, then moves back after any period of time. Do they lose the exclusion at all during this particular circumstance?
Well, this is kind of complicated. I may need to rely upon Nicole, but Prop 19 says that to inherit that tax base, it needs to be your primary residence, and you need to file the homeowners exemption. But if you move out, let's say your job transfers you to another state for a couple of years, it's no longer your primary residence. And because you are making a declaration in the homeowners exemption that under the penalty of perjury, that is your primary residence, I think a strict reading of the law would say it would not qualify. Nicole, is that your interpretation?
It's one of those things that's kind of difficult. And I think we debated this a lot. There are some times where that might be appropriate and it still remains someone's primary residence. And a couple of examples I can think of is, let's say if someone has a home as their principal residence and they had to go away for military duty. Obviously, it's still established that that's still their primary home. And of course, because of their military commitments, they're having to move out. So there are some instances, and we have to look at those specific ones. Like, for example, someone might have to go and convalesce for a while for a hospital facility. So there are instances where someone may temporarily move out of the home. As long as it's still designated as their principal residence or primary home, they may still be able to keep it, but we'd have to look at that in these circumstances in terms of someone moving out for a job thing. We'd have to look at the circumstances in between, but there's a possibility, I would say. But you're right, Assessor Jeffrang. Generally speaking, if people move out though, and particularly if they rent the home, at that point in time, they would lose the exclusion.
I will add that this type of scenario does put us in a very awkward and new position, because we are not an enforcement agency, but we are now obligated to determine residency of properties. We've never had to do anything like this before. Obviously, we want to do it to as much as possible, giving property owners the benefit of the doubt. This is something that's probably going to evolve over the next couple of years as we learn more about how these specific scenarios work, and we'll end up creating more local rules, and we'll probably work with the Board of Equalization to establish regulations on how to deal with the many varieties of people determining which property is their primary residence that qualifies for the exclusion. It will probably be difficult. I can envision a whole lot of different variations that will create challenges for us.
Got it. Well, thank you for providing some clarification on this. And Assessor, I did want to ask this final question to you because I know this is something that we talk to the public a lot about, but is there somewhere to check if the homeowner's exemption has been filed for a property? And where can audience members go to find this out?
So there's the easiest way is on our website, assessor.lacounty.gov. You can there's a search for a property tab. You can type in your property address, and your property will show up, and there will be on the right-hand side, there will be a little a menu. One of them says exemption. And if it says homeowners next to that word exemption, you're covered. You have the homeowner's exemption. If it's not there, then you need to file. But it's pretty easy to find. And I don't have an answer to this. Maybe Nicole or Robert, you'll have the answer. But somebody asked where on the tax bill it says whether you have the homeowner's exemption. I know it's on there, but I don't know where to direct people to see it on their tax bill.
Nicole, do you happen to know?
I was going to say, Robert can chime in if I'm incorrect, but they should actually see then that when they look at their assessed value, they should see the $7,000, it's exempted amount coming off of that. So they should be able to actually look at the top of the bill and see that that amount is there.
Okay, thank you.
It's being removed.
Great. And I do want to remind our attendees that I know we weren't able to get to every single question that has been submitted, but we will get back to you all in due time. As long as you did submit a question through the Q&A function. One of the great things about technology is we will have access to all of the questions you submitted after this webinar ends. So we at the Office of the Assessor and as well as BOE will be able to access these questions, and we will be providing additional answers to those individuals who we were not able to answer those questions for live. So please check back and we will make sure that we connect with you and get those additional questions answered. But I did want to thank all of our panelists for joining us today. Thank you to Assessor Jeffrang for taking the time out. Chairman Vasquez, thank you for providing some insight into the BOE, as well as Robbie Suzaki and Nicole White-Gamble from our office. Thank you for joining us and providing that very, very important clarifying information for the public. We know that Prop 19 is moving fast and there are a lot of questions out there. So we hope that we're able to answer some of those questions for you. Assessor, Chairman, would you like to leave us with any final words before we go ahead and wrap up our town hall?
I would just like to, first of all, thank you and Prang, your whole staff. Kudos for putting this thing together, and thank all the participants that logged on. And for those you mentioned that we weren't able to get to your questions, please, by all means, either reach out to the assessor's website or the BOE, and hopefully we can answer those questions. We do have a tax advocacy staff that could hopefully walk you through any specific and detailed questions we're able to answer. And there's just in closing, I just want to wish everybody a happy holiday, whatever holiday you do celebrate coming up in December.
And thank you, Tony, for joining us. Thank you, all of you, for participating. So this actually has accomplished what I hoped it would. We have over 104 questions. Just to reiterate, we're going to spend the next couple of days answering these questions. We will post them on our website. If we have your email address, we will email the answers. We got a lot of material today, and what I was particularly interested in was a lot of the nuances of the individual transactions that will help us draft legislation to clarify those points. Because as I had indicated earlier, we're not policymakers. So if the law doesn't give us discretion, then we can't make things up. We can only do what the law allows us to. And clearly there's a lot of nuances that are coming to our attention that we want to make sure we're able to address. And secondly, I did want to emphasize, and again, apologize, there is a significant backlog of Proposition 58 applications, that's the pre-Prop 19 law, as well as Proposition 19 applications. When I say there's going to be delays, I'm not talking about a couple of weeks. We are probably talking several months. Prior to this, our processing period for homeowners exemptions was about 8 months, and still a paper-based form. I just urge you to be patient. If there are any penalties or supplementals applied as a result of those delays, those things will all be retroactive to the point that those applications were submitted, and refunds will be submitted. So I appreciate your patience. We did want to communicate that to you, that there is a very long wait with these applications.
Right. And that being said, I want to thank everyone again for logging in and for joining us. If you had friends, family members, neighbors who wanted to attend but were not able to, this webinar will be posted on our website at www.assessor.lacounty.gov/Prop19. So this webinar is recorded. It is available to you as a resource. And like the assessor mentioned and Chairman Vasquez mentioned, we will be answering those questions that we weren't able to get to. So I want to thank you, the audience again. Thank you to our panelists for joining us, and have a happy holidays.